I was asked to speak about the legal framework for Women at Work, which is quite a wide ambit for a brief talk today, because just one chapter of the legal regulation, which covers maternity and parental rights, it's 670 pages, so that's just one tiny element. So I'll try not to take you through all of that. So I was going to have a brief look at the current legislation and regulation for women at work and the protection and retention of women at work against the backdrop of the statistics we've been talking about today. I was going to have a brief look at the case for quotas, looking at Norway, looking at European Commission's view, and looking at the stance taken in the UK, but we have touched upon that a little bit. And then I'm going to look at future regulation for women at work and keeping them in the career ladder, and that's quite topical because Nick Clegg made certain announcements last week which affected that. And then finally, I mean, we've had some fantastic tips from Geraldine earlier about how to keep your senior and women at all levels climbing the ladder. It is a very hot topic, considering that women make up half of Britain's workforce, but only 1 in 5 are in senior roles. And Nicola referred to the advertising industry's 13.5%, which comes out of the IPA census, which is not good. But it is a high priority, hot topic at every level. At government level, they've recognised it's got to be addressed because gender equality means a 35% increase in gross domestic product, and that's a big increase. So it's not just a nationwide issue, it's an issue at company level too. And as everyone has said today, gender equality and mixed gender teams achieve greater profits for you. As both Gail and Geraldine said earlier, women make up approximately sort of 80 to 85% of the consumer spending decisions. So in this industry, it is very important that tactically we try and ensure that we have equal men and women at board level, because there was another statistic I saw which said that white males are responsible for 75% of advertisements, so that is quite telling. Now, Sex Discrimination Act is the sort of touchstone of equality legislation, and it's very important to make sure that your advertising agency can't be accused of being stuck in the Mad Men era. And so you do need to, at the very least, adhere to the basic legal framework for protection of women at work, and ideally embrace that legal framework. And I know I shouldn't really be speaking telling you all how to do this because you're here and you're recognising the importance of that. But if you don't, then you won't retain your best female talent. They'll move on elsewhere. And at worst, you could end up in a situation where you're facing an employment tribunal claim, which is going to be very bad PR indeed. And as quite a few of you may be noticing, if you're doing government work or charity work or got big blue chip corporate clients, increasingly you'll be finding in your pitches, you're going to have to say what you're doing in the workplace in terms of diversity, gender equality, etc., because they see that as a big issue. They want to know what your corporate culture is like because they do not want their product associated with an outdated or outmoded or sexist agency. So whilst I'm going to go through the legal framework, I'm going to say it's not just a tick box exercise. It should be embracing a general cultural awareness at all times. So the equality legislation goes back a huge way. 1975, Sex Discrimination Act came in, and that's now been incorporated into the wider Equality Act, which covers age discrimination, disability discrimination, etc. And that's promoting the principle of equal treatment for men and women at every stage in the employment cycle, from recruitment through to promotion, working conditions, dismissals, etc. And I've referred to some fairly legalistic phrases here, I'm afraid. But under the Equality Act, it's obviously unlawful for an employer to directly discriminate against a job applicant or an employee by treating them less favourably because of sex. And I think incidents of that are on the wane, but obvious example is rejecting a candidate because they're of childbearing age and you're thinking they're just going to go off and we're going to lose them very quickly. Hopefully that's more of a thing of the past. Indirect discrimination is where you've got a policy or criteria or practice that's going to adversely affect one particular group of either men or women in one particular case. So, for example, if you were to change all your working hours and say people have got to be there from later on 10 o'clock till 6 o'clock, or we're going to extend the working hours, that's going to adversely affect those with primary childcare responsibility, which is women. Victimisation is a legal phrase. It doesn't mean people have got a claim if they think they're being picked on. It's if they have threatened to make a complaint or have made a complaint that they've been discriminated against on the grounds of sex. So that's a whistle-stop tour of the Sex Discrimination Act. I don't want to be a scaremongerer, but I'm a lawyer, so I've got to focus on the risks as well. You've just got to be aware that you can be vicariously liable for your employees. So, the laddish culture, you just have to be aware of and try and contain that as best as possible. But also, you have to be careful about what's happening with your clients and at client events, because actually now, unfortunately, you can be liable if one of your clients has subjected one of your employees to harassment in the workplace. If it's been in the course of their employment and you have failed to take steps that are reasonably necessary to prevent that person from continuing. And if you knew about the harassment, so if you had a complaint from one of your grads who'd been out on a PR exercise and had been subject to those sorts of issues, you need to take action. You can't brush it under the carpet and think, well, client is king, put your best short skirt on, etc. And I know none of you would do that, but it is just something to be aware of. And it's, harassment is not just a sort of groping issue either. It can occur in sort of most tangential situations. It could be just an issue of someone taking offence to one of their co-workers having lots of page 3 pictures up on their desk. Or I had one bizarre complaint when I was dealing with clients in the city about how they always used to have this email announcement about the sandwich lady coming, and there'd be an announcement which room she was in, and one employee gleefully sent out an email saying, "Sandwich lady's got her baps out in room 3." And, amusing comment, but someone did take offence. And the reason why I've sort of gone back to these basic issues is just that the Jimmy Savile scandal has sort of highlighted some issues in BBC and radio, etc., about sexual harassment of women, and some who've apparently seemed very robust and been able to cope with this. It's been highlighted, it's been going on and still going on. So tips from the employment lawyer perspective are just to make sure from the beginning of the employment relationship, the induction stage, if you've got policies in place, yes, emphasis should be placed on adhering to them. And it should just be a normal part of the culture that you've got policies and procedures in place covering issues. So if an employee's got a grievance, they feel they know who to go to, they feel they can make a complaint and it can be addressed. And this has been touched upon earlier as well. Training managers, or training your staff at all levels. Managers should be aware that they need to keep an eye out for inappropriate customs and practices and cultures in the working environment, and just make sure it doesn't continue and try and stamp it out. And I appreciate it in this industry, it's very hard. It is a laddish culture, and by and large people accept that and get on with it. But it's just setting the ground rules from the start, if you can, so people know the score when they start work. So women's rights in the workplace, well, as I said earlier, huge range of them, and you can't be expected to know the ins and outs of the regulations and the rules, but it's important just to consider the main key areas that impact on and support and help retain women in the workplace. Maternity, you all will be familiar with the key rights, so I'm not going to go through that in any detail. There are a couple of issues, though, which I come across in my day-to-day inquiries. from agencies. One thing is the contract. That does stay in force. People are entitled to receive all their contractual benefits except for remuneration. Now, keeping in touch is a big issue. This is where a number of companies and agencies do fall down. It is a really common mistake for agencies to assume, oh, shouldn't have any contact at all. They're going to be busy. They've got a screaming child. I mustn't ring up and tell them, unfortunately, we've got to make some redundancies, or we've got to restructure, or we've lost this big client. We'll just keep out of it. And at worst, some people assume, and this is very much the minority, but some people assume that woman is not going to come back. But it is important to keep in touch, and perhaps it's useful to have opt-in, opt-out forms that you can give people before they go on maternity leave, and they can say how much they want, if they want to know about the Christmas party, where that's coming along, and so they can stay in the loop or not, as the case may be. It'll be up to them. So returning to work, that is another area where I face a number of issues and inquiries and questions. Again, the first common misunderstanding is that the employee must tell their employer when during the maternity leave they are planning on coming back to work. Well, no. You assume they're coming back 52 weeks later, and it's the date they've put on their MAT B1 form. The second issue I often face is it's assumed that women can just come back to work and be given something of an equivalent level of seniority, but not exactly the same job. No, if a woman's been on ordinary maternity leave, which is the first 6 months, they're entitled to return to the same job that they occupied before, on the same terms and conditions as if they'd never been absent. Additional maternity leave is the second 6 months, and again, they're entitled to return to the same job, same terms and conditions as they were on before they were absent. But there's just one slight get-out clause that if it's not reasonably practicable for you to do that, then you can offer them suitable alternative employment on the same level of terms and conditions. But that doesn't cover redundancy situations. It would cover something like if there had been a restructure of the agency and the work had changed substantially as a result. And that leads us on to the less optimistic, I'm afraid, issue of redundancy. Obviously, redundancy can't be caused by pregnancy or maternity leave itself. But again, this does crop up. I have faced inquiries where people have come to me and said, well, actually, we've done fine with this person not being here. We've redistributed the work. Or in fact, actually, maternity leave cover has been brilliant. So we haven't got a job for this person to come back to. So is it all right if we make her redundant? Which always brings me out in a bit of a cold sweat, I'm afraid, because the result is potentially automatic unfair dismissal claim, or in its unlawful discrimination. And again, I'm sure this is not an issue with your agencies, which is why you're here. But another issue to consider is that maternity leavers get precedence over other employees in terms of suitable alternative employment. So if you are carrying out a redundancy process, again, you need to make sure you don't ignore that person who's on maternity leave. You get them involved, or ask them if they want to be involved, come in for meetings, but if you've got one position of suitable alternative employment, needs to go to them. Which brings me on to the next big issue of flexible working. The 16%, that's from the IPA census as well. CIPD argues that the right to request flexible working is an example of light touch regulation that helps to support business performance. And the key point is it's the right to request flexible working, it's not the right to have it. There are several do's and don'ts. There is a flexible working process. It's a statutory procedure which is quite cumbersome. It's a very explicit black and white procedure which you need to follow, and you do need to follow that process, and it is a tick box exercise, I'm afraid. And we've got template policies and procedures on the IPA website, on the employment page, so you can look them up there. Because if you fail to do that, then technically an individual can bring a claim to the employment tribunal, and they can receive up to 8 weeks statutory pay, which is £430 a week at the moment. And the tribunal can order the employer to reconsider the application. Although it is a tick box exercise in terms of the procedure, you do genuinely need to consider it and talk it through with the employee. Don't just dismiss things out of hand. Listen to their suggestions, You could always consider a trial period of 3 months and say you're going to review it after that and see how it's worked, because it won't be the right thing for the individual either. But also, if you said yes to one employee, it doesn't necessarily mean you have to say yes to another. Each case is dealt with on its own facts. And don't forget that if you do agree to part-time working, it is a permanent change to that individual's contract of employment, so you can't change your mind a year down the line. So keep an open mind. Don't be afraid to suggest other options. If someone says they want to work for 3 days a week, you can't do that. Maybe 4 days a week with 1 day at home, for example. I don't know if any of you saw, there was a programme on a few months ago, Hilary Davies, Women at the Top programme, but she was working out how they could try and stop women leaving at senior levels. And there was a case study on BT. BT has got a significant programme for part-time employees. They've said that each home worker saves them £600,000 worth of overhead costs. The head of sales there had half his workforce, including him, working from home. And they thought it worked. They thought it helped keep women at work, and was a very positive situation. And I appreciate that, of course, it is very hard in this industry, which is very client-focused, to be able to accommodate that every time. But it's a digital age. Do we really need to have everyone working in the office 9 to 5? And I know from experience during this summer, quite a few agencies did introduce some flexible working hours during the Olympics, and the feedback from that was very positive, and a number of people said, actually, I think we might open this up and continue this. So I think it's a positive thing, very positive situation. I've touched on parental leave. Really, parental leave take-up has been low, but I think that's because it is unpaid. There was another rather frightening statistic. In 2005, only 8% of fathers used parental leave. And of those that did, 3/4 took less than a week. So that's one right that has seemed to be taken up by women only. I'm not going to concentrate on time off for dependents, but it's basically another example of a framework that women can rely on, or men, if there's an emergency situation with childcare, etc., or your child is ill, or if you're caring for elderly relatives and you need to deal with an emergency there. Now, I've also looked at paternity leave, because I don't get many inquiries on this. And obviously there's a significantly, I haven't actually come across very many inquiries at all about additional paternity leave that men can currently take and have been able to since April 2011. I'm going to talk about forthcoming changes to this. But it does reflect the fact that people still think childrearing is a woman's job, and we've discussed this today, and it's a culture issue across all industries, not just ours. But I think it is important that if you do have requests from dads or potential dads to take paternity leave or additional paternity leave, or in the future the shared flexible parental leave, consider it seriously, because many men, husbands, partners want to take a more active role in the home, and it is very much thought, oh no, if I ask for this is going to be completely taboo subject. I'm not going to be seen as seriously devoted to my job. I think there's definitely still a stigma attached to fathers who want to spend more time of the day at home. So I think actually it is easier for women to make flexible working requests, and I think the impact is that perhaps more employers are likely to accept a request from a woman, which perpetuates the whole cycle of more women working part-time or being at home. So just to be aware of this, there is this stereotyping which can be made worse. I'm appreciating time is of the essence at the moment. Equal pay I'm not going to go into because it's such a massive, complicated subject, but it was raised earlier by Gail. It's not just a public sector issue. There was a recent case also where the Supreme Court said that if an employee was out of time in bringing an employment tribunal claim, they can bring a claim for breach of contract in the High Court. Now, the impact of that is you have 6 months to bring an equal pay claim in the tribunal, but 6 years to bring an equal pay claim in the court. So it means that employers could face claims many years after the event, making evidence gathering and the employment lawyer's job very, very difficult. So the main issue is just to tackle equal pay issues and diversity issues before claims arise. So it's preventing rather than having to deal with it. So that is a very whistle-stop tour of the current legislation for protection of women work. But for some, equality legislation isn't sufficient, and that's why the whole issue of quotas coming up time and time again. And I'm briefly going to look at that. Norway has been quoted. That tops the European statistics on the petition of women in the workforce. It was the world's first to introduce paternity leave. I mean, their fathers are entitled to 10 weeks paternity leave as opposed to the 2 weeks here. And couples can opt for 46 weeks on full pay or 56 weeks on 80% pay. However, whilst they do have 40% female non-executive directors, only 2% at the CEO level. So only 2% really wield the top power. So we've touched on this issue of quotas. It's certainly a tool, perhaps breaks the cycle of old boys network, etc., and it does block top positions for women. So it's a speedier, immediate solution. But as also has been pointed out, investors are perhaps not so keen on this. And there are, so far in the UK, I'm going to look at the position here, but Women Equalities Minister has rejected mandated quotas. We are working on a voluntary approach here. And I think the feedback is that quotas target the visible problem of female underrepresentation, but not necessarily the causes. So we need to look at the broader issue of retaining talent and women at the workforce at the level that does reflect their skills and experience. So the UK is at the moment just trying to re-educate employers, making them realise, yes, there's a significant and untapped pool of potential boardroom talent. But the sort of backdrop to the UK's position has come from the Davies report, which has also been referred to earlier. That was in February 2011. And that was government commissioned, and it was a report entitled Women on Boards. And it wasn't all about promoting equal opportunities, it was about improving business performance. Lord Davies had identified the 3 factors for the case for securing more women on boards. We've covered that. You lose your talent if you don't incentivise, support and promote senior women. Substantial board female representation at board level means you outperform your less diverse competitors, and it's more responsive to the market as well. Women make up 51% of the UK population. So basically, it's been recognised, yes, we need to tackle this issue, and the issue of retaining women is largely due to the arrangements made for women going on and returning from maternity leave. It was also recognised there are some issues with recruitment at board level. Very few board positions are actually advertised or filled through a transparent, standard recruitment process. So that is perhaps one reason. Some people say, well, it's more men at board level, men recruit men, etc. So we had various recommendations from Lord Davies, who rejected quotas, and said, OK, we'll set targets which FTSE 100 companies can aspire to. And it's all with the intention of companies voluntarily increasing women on their boards and just increasing awareness of the business case for it. And I think as a result of the Lord Davies report, the Department for Business Innovation and Skills has start an inquiry into women in the workplace. That started in September. It's been extended and it'll complete in December, so we'll see what happens. But it's all about looking at remuneration, segregation, part-time working, gender stereotyping in certain sectors, particularly banking and construction. But as you may have noticed in the press, there is quite a tension between the need for regulation to protect employees, but also businesses' desire to cut red tape, and the government is very keen on doing that. So it'll be interesting just to see how they deal with that and what they conclude at the end of their consultation. And sort of moving on from this issue of quotas, as you may be aware, the approach to underrepresentation boards is rooted in corporate governance, and on the 1st of October there has been a change to, there's been a corporate governance code introduced, so listed companies have to have aspirational goals and annually report on their progress now. And that's with a view, I think, to that practice of extending through to smaller companies and for it to become normal practice. And from October next year, quoted companies will have to report on the overall number of women in the workplace, number of men and women on the board, and the numbers of each in executive positions. So that will have to be filed in annual reports from next year. So what of the legal position for women at work in the future? Well, as I mentioned earlier, Deputy Prime Minister Nick Clegg has announced from 2015 the UK will have a new system of flexible parental leave. I was discussing this with my boyfriend earlier this week. He said, yes, it's fantastic. Men now have a right to a year off. Brilliant. I said, no, it's not quite about that. After the first 2 weeks of a woman's maternity leave, the remaining 50 weeks can be shared between her and her partner. That leave can be taken in turns or by both partners at the same time, but you can take up to a maximum of 12 months, and 9 months will be at the same statutory pay at the moment. And that will replace the current system of additional paternity leave at the moment. And this right is going to be offered to parents of adopted children, and it's also going to be in action for surrogate parents too. Nick Clegg has postponed plans to increase paternity leave because there was opposition from government colleagues, businesses, etc., saying that it was going to be potentially damaging for fragile economy, and they didn't want increased regulation. So it's back to this issue again, but I think it has been received well so far, but what the key issue is going to be, it's got to be easy for employers to administer. Yes, great to have this potential, and I think it will certainly help achieve a cultural change, but it's a light touch change. It's not going to lead to an overnight change of increasing the number of senior women at board level. But it is certainly a step in the right direction, and hopefully it'll take a number of years, but it's going to just gradually, hopefully, trickle through. The other change on the horizon is increasing unpaid parental leave. So by 2015, each parent can exercise this right for children up to the age of 18. And the length of unpaid parental leave will increase as well from 13 to 18 weeks. Which again should hopefully encourage a sharing of parental responsibilities, but we'll have to see how it gets put into practice. And then flexible working as well, that's been touched upon earlier, that's going to be extended to all employees will have the right to request flexible working from 2014. So it's hoping that this is also going to increase sort of diversity in the workplace. It's going to encourage men and women to put forward these requests as well. And Nick Clegg said he hopes these future legislative changes will shatter the perception that women have to be the primary caregivers. But unfortunately, I do suspect it's going to be less of a shattering, more of a slow, gradual shift as a result of these reforms. But in terms of flexible working, it is anticipated that there will be a net benefit of 222 million to employers, because there will be reduced sickness, reduced absenteeism, reduced recruitment costs. So there is definitely a case for encouraging it. So finally, top tips. We've had loads today, which is absolutely fantastic. I think the key thing is be flexible and be creative, and you're the right industry to be creative. Don't be rigid in your approach or view. Deal with each case. If you get a request for flexible working, deal with it on its own facts. Yes, policies like maternity leave and pay policies, flexible working policies, parental leave policies are important. Policy and procedure is, I'm afraid, a touchstone of employment law. But it isn't just a tick box exercise. It is embracing it at each stages of the employment cycle. So yes, training and development is very important, from the induction stage, from your new recruits, all the way through to support and career planning, etc. And we've talked about sponsorship, mentoring, and that's so important, and diversity training for employees at all levels. As regards female role models, I say if you've got them, flaunt them. Very, very important. And then finally, well, how are we getting on with breaking that glass ceiling? Well, it's not all bad news. It's not all negative. Following Lord Davies' report, women directors did go up from 12.5% to 15.6% within FTSE 100 firms. It is slow progress, but positive measures have been brought about by corporate governance, voluntary measures, new family-friendly legislation. But certainly as far as the EU is concerned, or the European Commission, it's not fast enough. So there is this widening and mounting concern about the big gap in approach between different European countries about the presence of women on boards. So really my view is that the best way forward, I think for us in this situation, is to create the environment in which women can be retained, work, can develop their skills, and perhaps work on a more flexible basis during active childcare years. And this will apply equally to men as well. So it is looking at the pool of talent that you have available to you and how best you can use them, rather than rigidly thinking clients are going to demand that everyone is full-time working in the office 9 to 5. We've got increased globalization. We're in a digital era. Diverse boards at every level, from age, gender, ethnic origin, religion, is, I think, becoming from a marginal issue into a business imperative. And I think ultimately, yes, quotas have their job, their place, but it's going to be competitive pressure that's going to be the most motivating force for most companies, and that will create your talent pipeline. If you don't redress the balance of men and women at the top, you'll be left behind by organisations that do, and that do promote diversity of thought. But finally, don't worry. I know there's been lots of talk about what you should do, shouldn't do, etc. And I think all of you here are well on the way to promoting best practice. And you shouldn't think the advertising industry is worse than any other. I've come from the legal profession, and believe you me, there is a very serious issue there. I mean, there you have 6 out of 10 graduates women, but only, I think it's sort of 3 out of 10 are partner level. And there's only a certain amount you can do in the workplace as employers. There is also the economic issue of the cost of childcare, which is phenomenal, and for some it's just a no-brainer. It's going to cost more than if I go back to work. So there are a lot of complex issues, and you can't be responsible for doing all this. But if you do comply with the legislation and encourage sort of flexible working men and women, and just try and promote career breaks and training, etc., during the active childcare years, then you are going to do a lot to improve the lot of women in the advertising industry and the future of women in the advertising industry. And you'll retain your very invaluable talent. So thank you very much.